Criminal Appeals of Tennessee is now in session.
Welcome, everyone, to this call of the April docket here in Jackson, Tennessee. This will be the second case of the morning, and I will have more to say after we call the case. Madam Clerk, would you please call the second case?
State of Tennessee versus Terry Newsom.
Seeing both counsel, knowing you very familiar with this protocol that we're using at this particular point in time, I just want to remind you that each side has 20 minutes. If you like any rebuttal time, please do so upon introducing yourself to the court. This particular protocol and this manner in which we are conducting our oral arguments on Zoom and on YouTube are the same as if you were in person. And with that, I will ask that the appellant time starts now.
Thank you, Judge Williams, and good morning, Your Honors. May it please the court. Kendall Stivers Jones with the Appellate Division of the Public Defenders Conference on behalf of Mr. Terry Newsom. Judge Williams, may I reserve 3 minutes for rebuttal, please, sir?
Yes, ma'am. I'll help you keep up with that.
Thank you, Judge. Your Honors, Mr. Newsom's appeal today is from a jury verdict that resulted in 3 convictions: felony evading, misdemeanor reckless endangerment as a lesser included of the felony reckless endangerment, and driving while his privileges to do so were revoked, canceled, or suspended. The convictions in this case stemmed from Mr. Newsom's flight in a vehicle from an officer who had initiated his blue lights. Mr. Newsom and or his vehicle then failed to make a turn in the road when he was driving, and he wrecked into some building materials that were left on a lot. When the vehicle stopped, Mr. Newsom continued on foot until an officer convinced him to stop with the aid of his taser. Mr. Newsom had 2 passengers in his car at the time, an adult friend who was in the front seat and his 9-year-old daughter who was in the back seat. The daughter was buckled in the entire time. All the occupants of the vehicle had no injuries, and the officer testified that the pursuit lasted a maximum of 1 to 2 minutes from the time he cut his lights on until the vehicle wrecked. He testified only that Mr. Newsom was driving above the speed limit, although there was no testimony as to what that speed limit was. Mr. Newsom was sentenced to a cumulative sentence of 3 years to serve as a range to offender, and the trial court imposed the $4,250 that the jury assessed in fines without making any findings. Based on those facts, we argue that this court should reverse the judgment of the trial court on 3 grounds. First, we ask this court to reverse and vacate Mr. Newsom's conviction for reckless endangerment because there was insufficient evidence to support this conviction, and more specifically that any rational trier of fact could have found beyond a reasonable doubt that anyone inside the vehicle, including Mr. Newsom's daughter, was placed in imminent danger of death or serious bodily injury during the 1 to 2 minute drive away from the police officer. We are not addressing the sufficiency of either the felony evading or the driving while license was suspended. Second, this court should reverse and remand this case for a new sentencing hearing. The trial court erred in determining Mr. Newsom should serve his sentence because the determination was based solely on the need to avoid depreciating the seriousness of the offense. And third and finally, this court should reject the jury fines and remand this matter because the trial court did not make the required findings about Mr. Newsom's ability to pay before imposing the jury fines.
Well, now tell me what he has to do there. I'm seeing a few of these come up nowadays, and I thought I had a pretty good handle on what the law was there. But tell me again what the judge you think has to do concerning this fine.
It's similar to the trial judge has the authority and has to make specific findings on the record regarding the fine. Since the fine is considered part of the sentence, it's something that the trial court has to consider before imposing it.
So what does he have to consider the ability to pay at that time?
Yes, Your Honor. He has to consider. Yeah, sure. But it's the case that I provided when determining the defendant's sentence, the trial court cannot automatically impose these fines. So it's similar maybe to akin to restitution. There has to be some kind of findings on the record about his ability to pay. Now, being indigent is one of those factors. It's not the only factor, but the trial court does have to go through make certain findings about his ability to pay those fines before imposing the jury's fine, what the jury assessed in this case. I know the state has mentioned in its brief or argued in its brief that this issue was waived in our case. There was no mention or objection to the fines at the time of sentencing made by trial counsel. And we argue in that regard that because this is a sentencing issue, it is not waived because of that. Now, I am aware of this court's recent opinion in Jadarius Foster that you run the risk of waiving. But nevertheless, since the fine is part of the sentence, it is something that it is not waived and is not specifically required by TRAP 3E or Tennessee Rule of Appellate Procedure 3E as something that anything other that we would be seeking a basis for a new trial, since we're not doing something that would require a new trial.
So the fine here was $4,250. Is that correct?
Yes, Your Honor. And only $50 of that was mandatory by statute. Okay,
so the jury was pretty much set the fine at $4,250.
Yes, Your Honor.
During the trial, did the defendant acknowledge he was driving a car?
Yes, Your Honor. He did.
He tested.
It was not his car. It was Mr. Fuller's car, who was the front seat passenger. He did acknowledge he was driving. He did acknowledge that he saw the blue lights. He did acknowledge that he kept going. So there's no question.
Was there any evidence adduced either at the sentencing hearing or in a pre-sentence report that he owned property or had a job? Or I mean, $4,500 is not an exorbitant fine.
Not exorbitant, but it is for someone. The testimony at his sentencing hearing, he had worked. He was a convicted felon. His convictions were in the 90s, but I think he was finally released from the service of his sentence in somewhere around 2010, and had some misdemeanor offenses since that time, but no felonies. He would have been working at Kellogg's in Jackson for about 6 years. His long-term girlfriend testified. He had no property. They rented together. So the only thing that he had was there wasn't any testimony either about any kind of responsibilities by a court in terms of child support or anything like that, but he did not own any property according to what was adduced at the sentencing hearing.
Okay. Now you made a statement earlier that the trial court only confined the gentleman because of depreciating the seriousness of the offense.
That was the tipping point. Now, the trial court did consider other factors, but that he considered the enhancement and mitigating factors and made findings on the record as to which ones did apply and which ones did not. He also weighed his prior history, but the tipping point, which is what the statute addresses, is the tipping point that outweighed all other sentencing factors in terms of a suspended sentence. The nature of the offense had to have been something that was, he made the ultimate tipping point was that to not confine because of the facts of the case would have depreciated the seriousness of the offense. And I think there was something else that the trial court mentioned about the need to protect individuals, but it seemed like it was from the facts of the case and not necessarily the criminal history, which is what that factor, the confinement factor, addresses. And in that, we would argue that this case was not, the tipping point was not one that was appropriate because the when he relied on the facts and circumstances of this offense, it has to be something that is especially violent, horrifying, reprehensible. I think the language goes offensive, something that would go above and beyond what would be necessary to establish the elements for a jury verdict of guilty.
I'm not familiar with that either. I must be having a senior moment today. He's got a criminal history. He can take that into account, right? And he could
Absolutely.
And he could do it on the criminal. How do you determine what the tipping point is as a judge? I don't know that I'm able to do that.
Well, I guess it's like this, sentencing now rather than, rather than presumption speaks of favorable, unfavorable, or not weighing for or against. So the trial court mentioned that an enhancing factor, for example, didn't apply. He didn't find consecutive to apply because of an extensive criminal. He didn't find that would be appropriate in the case. And he didn't find or apply the enhancement factor that Mr. Newsom acted without regard for, or acted when there was a risk, when the risk of life was high, to risk of serious bodily injury or death was high to others. That would tend to indicate or be counter to deciding in favor of confinement rather than a suspended sentence.
Well, what if it's an element of the offense?
Well, that would get into our argument on sufficiency for the reckless endangerment. Because the reckless endangerment
if we determine that it was sufficient, then doesn't that preclude him from finding that as an aggravating factor?
It could, but it would have to be of an especially egregious nature. And I don't mean to be coy, but it would be something that would be determined on the facts. For example, in this case, for the sufficiency, even if the jury found that Mr. Newsom was speeding, even taking everything into account that the speeding was the cause of his wreck, that in and of itself, this case doesn't factually distinguish itself enough that there's no difference between what happened here necessarily and a single car crash with no injuries. The only difference would be that he happened to have his daughter in the car and that he was not obeying the commands of the police officer to stop. The statute speaks of imminent danger, and this has been interpreted to mean not just a mere possibility of death or serious bodily injury, but a reasonable probability. It doesn't speak to that. Although the indictment doesn't mention any specific individual, and it doesn't have to, as long as they show that somebody's in the zone of danger. They don't ever speak to Mr. Fuller, who would have been the other person in the vehicle. The state and the defense, to be fair, only mention the daughter. And the state mentions in its brief that the indictment mentions an erratic or reckless manner, and the state mentions in its brief that the car could just as well have come to a stop by crashing with the same significant force of an oncoming car, a house, or a utility pole. And the fact of the matter is that the video shows Mr. Newsom passing approximately 9 cars, passing houses, passing utility poles, and didn't hit a single one of them. And that, we argue, is the very definition of a mere possibility rather than a reasonable probability.
Ms. Stiles, can I ask you, if I remember correctly, didn't he go over a couple of speed bumps at a high rate of speed?
Oh, yes.
And didn't he wreck because he failed to negotiate a curve?
Yes, Your Honor.
So those aren't possibilities. Those are things that were definitely shown by the evidence.
That's true. And even taking that as true, we don't know, what the factors to be considered. We would argue it would be a case-by-case basis, but the speed, even if he was speeding, taking that as true, which we have to because the jury obviously found that, even taking that as true, we have no evidence of what the speed limit is. 15 miles over the speed limit in a 30-mile-per-hour zone is going to be different than 30 miles or than 15 miles per hour over the speed limit on I-40. There were no inclement weather conditions that he should have been aware of. He did not hit anybody else that was passing by him. If you take going too fast over a speed bump or failing to negotiate a turn, that in and of itself is not necessarily something that a parent taking their child to school when they're late might be. The only thing that differentiates it here is what the state focused on, which was he had failed to obey the lawful command of an officer who had signaled his lights, and that he had his daughter in the car, even though she was buckled in. So that in and of itself, taking out that kind of stigmatizing factor, which doesn't really add anything to it's not more dangerous because a police officer has signaled his lights and you've not stopped. It would be more dangerous perhaps because of the speed or failing to negotiate a turn, but the evidence in this case is not enough to distinguish that from the driving habits of anybody else. That's what we have focused on in this. Those two factors have kind of convoluted what would normally be just an accident. There's no mention ever of Mr. Fuller, despite the fact that he is in the exact same danger as the daughter. He's in the front seat. There was no evidence. I don't believe he testified as to whether or not he was wearing a seatbelt, and he was subject to the same driving that the state is arguing put the child in danger, but not him. This we argue is just simply not enough factually to distinguish this from any other car accident. And if the court has no further questions, I will turn it over to counsel for the state and reserve the rest of my time.
Thank you. General?
May it please the court, Catherine Decker, representing the state of Tennessee. The defendant is not entitled to relief on any of his claims. Turning to the first issue, the evidence was sufficient to support the defendant's conviction for misdemeanor reckless endangerment. So I'll say at the outset that defense counsel is absolutely true that we both focused on the daughter as the passenger. Defense counsel challenged in his brief, defendant challenged in his brief only the sufficiency of the evidence relating to putting the daughter in danger. And so I, in turn, focused on that. But either our arguments can apply across the board to Mr. Fuller as well. I don't think that defendant is conceding sufficiency of the evidence for Mr. Fuller just because he didn't mention it is in his brief. The arguments apply equally to both passengers. So specifically, properly viewing the evidence in the light most favorable to the state, ample evidence allowed the jury to rationally conclude that the defendant placed or may have placed his passengers in imminent danger of serious bodily injury or death by driving in such a way that he lost control of his car while traveling at a high rate of speed. As the old adage goes, speed kills. The evidence sufficiently established that the defendant was driving at an excessive speed through a well-traveled neighborhood at night in his attempt to evade the police during the police chase that lasted 1 to 2 minutes. Now, defense counsel has represented that Officer Baird, who was the officer following the defendant, said only that the defendant was traveling above the speed limit. But that is not actually what Officer Baird said. What Officer Baird said was that the defendant was traveling at a high, this is a quote, a high rate of speed. And the jury was free to credit that testimony. Officer Baird also testified that when he was already following the defendant sped up, and Officer Baird had to accelerate to 60 miles an hour to catch back up with the defendant. He testified that the defendant was traveling at a similar rate of speed. And the jury was free again to credit that testimony. And from that testimony, it was rational that the jury could conclude that the defendant was traveling at about 60 miles an hour through the residential neighborhood. Defense counsel's correct. There's no evidence of what the speed limit was in that neighborhood. But there's a video, the video that was introduced at trial provides some evidence of that. First of all, the video provides evidence first that the defendant was traveling at a high rate of speed. You can just watch the video and see with your own eyes that the defendant's traveling at a high rate of speed. But more than that, if you, as I mentioned in my brief, if you look at, there's two cars that travel from the top of the screen of the video to the bottom, two separate cars. It takes them 19 seconds to do that. The defendant, traveling the exact same route, travels it in 12 seconds. So he's traveling at 1.5 times the speed of two other cars that you can see in the video. And the jurors could rationally conclude that two separate cars were traveling about the speed limit, and that it was the defendant that was traveling over the speed limit, and 1.5 times as fast is, rationally, they can conclude that that's considerably more than the speed limit in a residential neighborhood. And also, even looking at just that portion of Lincoln Street that's shown on that video, and that's not the entirety of the chase, but just that portion of the video shows that in 4.5 minutes or so, 9 cars traveled down that street and doing what cars normally do, traveling down it, backing up, making a turn in the street. Those kinds of encounters, the defendant reasonably put his passengers in danger by traveling down that street at a high rate of speed, because given the shortened reaction time that comes with excessive speed, the jurors could rationally have concluded that the defendant's speed alone, his speed alone, created a reasonable probability of causing serious bodily injury or death to his passengers by colliding with one of those cars, doing what cars normally do that we can see on the video in just that short route down Lincoln Street. But additionally, the defendant's conviction was supported by evidence that he was driving in such a way that he lost control of his car. The defendant himself testified multiple places that he tried to stop his car, but it would not stop. The defendant lost control of his car, it jumped over a curb, and it crashed into some cinder blocks in that field. The defendant himself testified that what stopped the car was the cinder blocks. He was not able to come to a controlled stop. And he crashed into the cinder blocks with enough force to cause significant damage to the front of his car that you can see in the photographs admitted at trial, and also officers testified that it caused significant damage. Instead of the cinder blocks, the jurors could rationally have concluded that the defendant's out-of-control car could have crashed into anything. It could have crashed into another car, a utility pole, a house, anything with the same significant force. So again, viewing the evidence in the light most favorable to the state, the jury could rationally have concluded that the defendant placed his passengers in imminent danger of serious bodily injury or death by driving at high speed in such a way that he lost control of his car. And the defendant is not entitled to relief on his challenge to the sufficiency of the evidence. Unless there are any questions concerning that issue.
I have one, but not that issue. So I interrupted you too quickly. You go ahead.
I'll turn to issue number 2 concerning sentence of confinement. Defendant doesn't seem to contest that the trial court would have properly sentenced him if the sentence had been based on more than the confinement factor of confinement is necessary in order not to depreciate the seriousness of the offense. But that's exactly what happened here. And to Judge Williams' question, no, that was not the sole factor that the trial counsel relied on. The trial court stated expressly that it considered the evidence at trial, the evidence at the sentencing hearing, the pre-sentence investigation report, sentencing principles, arguments of counsel, etc. It then reviewed the facts and circumstances of the offense, and as I've quoted in my brief, it found them to be to put passengers in danger and to be a terrible situation. So it considered the facts and circumstances of the offense, but then it expressly said that it was considering the defendant's criminal history. And as I've set out in my brief, it's extensive. It includes 15 prior convictions. And the court noted that expressly. And the court that went on to say, and this is even quoted in defense brief, under the circumstances, I think the interest here is as far as interest of society and protecting individuals. And that is Confinement Factor 103A, which is that the trial court can order confinement when it's necessary to protect society by restraining a defendant who has a long history of criminal conduct. The trial court expressly found that factor. The trial court also found 103(1)(b), which is confinement necessary to avoid depreciating of the seriousness of the offense, but it was not the sole factor. Now, there's no evidence that the trial court, that there was any tipping point. There's no evidence of which of these factors was a tipping point. That's a construct by the defendant. But the trial court never said, this is the tipping point. The court said, interest of society in protecting individuals and the fact that confinement would be necessary to depreciate these years. It just, both of them. It's that simple. So I think that answers the issue number 2, unless there are any questions. I will note as well that defense counsel has, in the defendant's initial brief, said that the court didn't consider community corrections, but the defendant never asked for community corrections. And this court has held that when the defendant does not request community corrections as an alternative sentence, he has waived that. There was no request. The trial court, that was not brought to the attention of the trial court. Unless there are any questions concerning issue number 2, I'll turn to issue number 3. So this defendant asked this court to remand the case to the trial court to make findings, specific findings about his ability to pay the fines that were imposed. There's no actual express requirement by statute or in case law that says a trial court must make specific findings about the defendant's ability to pay. That's just not true. It's not akin to restitution. It's different than restitution. It's just not akin to that. There's no requirement for that. It is true that a defendant's ability to pay is one of a handful of factors that the trial court would use in determining whether to impose the fines that the jury fixed. But there's no requirement that he make express findings. This court need not remand this case for such findings.
Well, let me ask this. This is the second time I've heard this argument recently. And I guess I was a trial judge for 16 years, and I never knew that I had to find the ability to pay once the jury sets the fine. So then maybe this argument is more appropriate for Ms. Stivers, but if the jury comes back, they're instructed, other than setting the fine, the jury should not concern itself with punishment. The fine is $0 to $1,000. No fine is required. So if the jury comes back and sets a 0 fine, then I can have a sentencing hearing and I can say, well, I know you got the ability to pay. I just heard proof of that. I set the fine at $5,000 and disregard what the jury says. To me, it's the same as the jury sets the fine at $5,000 and reducing it to $100. I just, this is news to me. And again, that happens sometimes, but
it's news because it's not the requirement. It's a new argument that's being made, but it's not required. Now, there are cases, and the defendant cites them in his brief, where it seems that the trial court did not understand that it had that it did not have to rubber stamp whatever the jury said. So you have the trial court vocalizing on the record, well, I disagree and da-da-da-da, but the jury fixed the fine, so I'm obligated to impose it. And that is incorrect thinking on the part of the trial court, because the trial court is not obligated to pass through rubber stamp the jury's fixing of the fine that the jury fixed. But there's no affirmative evidence that the trial court did that in the case. The trial court noted that the jury fixed a fine and said, I impose that fine. I will note as well, though, that even in the Bivens case that defendant relies on in his brief, the court notes that the trial court erroneously thought that it had to, in essence, rubber stamp the jury's fixing of the fine, but went on to say, well, let's look at the factors and the defendant's ability to pay, and based on all of the factors that I've set out in my brief, the defendant in Bivens is not entitled to relief. And that's part of my argument here, is that there's no need to remand, because let's just assume, for purposes of this argument, that the defendant is not able to pay the fine. It's not dispositive, because the fine is supported by the defendants. These are factors that, by case law, support fines. Extensive criminal history, and the defendant's inability to abide by the conditions of probation. You'll see in the pre-sentence investigation report that he had probation revoked, and then 2 parole violations. So that's a factor too in whether to impose fines, is his inability to abide by his evidence that he lacks the potential for rehabilitation. And in addition, another factor in imposing the fines is the circumstances of the offenses that support the fine. And certainly you have that here, where the defendant's actions undermine the authority of the police and put his passengers, including his 9-year-old daughter, in imminent danger of death or serious bodily injury. And so based on those factors, there's no reason to remand for a determination of whether the defendant was able to pay the fine, because it's not dispositive. I will note as well, Judge Williams asked if there's any evidence that the defendant owned any property. There's no evidence that he owned real property, but on page 16 of the pre-sentence investigation report, it's noted that the defendant owned a truck and was paying on a car. So you must assume he has some kind of, equity in that car. So, that might indicate his ability to pay only $4,500 because of the value of most trucks and some kind of equity in the car. So that's the evidence. But
I'm sort of with Judge Holloway on this. I've heard this argument now. I think Judge Holloway and I said last week and this week, and I'm going to sit next week too. But this is the first I've ever heard of this argument since I've been on the bench, that the judge needs to be taken into consideration in finding out an ability to pay that day of the sentencing. Sometimes when probation is revoked and for payment of pay fines and costs, there you make a determination that he had an ability to pay. But it would only be at that time. It would never be upon the initial setting of the fine. I'll be interested to do some research on this, and thank y'all for helping today on it.
I do want to mention as well about the issue of waiver. I cited cases in my brief where this court has found that the issue was waived because on the principle that it was the first time that it was brought, that it was raised for the first time on appeal. That's the principle. And that's the principle that Judge McMullen picked up on in the Foster case. And because it was not, there was no complaint at all during sentencing as to the amount of the fines. And of course, at the time of the sentencing hearing, the defendant knew what the amount of the fines that the jury had fixed, had a perfect opportunity of presenting evidence that he was unable to pay those fines and failed to do so, failed to complain on the motion for new trial. So this on appeal is the first time that any court has heard of this complaint. And it's on that principle that Judge McMullen, and sua sponte, by the way, because the state and Foster didn't even raise waiver. It was Judge McMullen, sua sponte, and Judge Williams was on the panel that raised this issue and said when this is the first time it's been heard that the defendant's in danger of waiving it. And I've cited cases as well that on that principle. And so, but whether we go under plain error review or plenary review, the result is exactly the same. There's no reason to remand this because the defendant's ability to pay is not dispositive, and the fines were supported by those other factors that play into and justify the imposition of the facts imposed by the jury. So, unless there are further questions, I'll just ask this court to affirm the judgments of the trial court.
Thank you. We'll hear back from the appellant.
Thank you, Your Honor. I'll just clarify two things. I agree with the state that it is a reasonable inference to conclude that Mr. Newsom was speeding in the video, but not necessarily 1.5 times. The nature of the capture of the video is not such that it arouse really it's something that shows maybe every 1.5 seconds. So it's not really a real-time way of evaluating how far it takes for one car to get through the frame. And two, on the issue of fines, the case law that we cite is still good law. It's a 97 case, but it's a reported case from the Court of Criminal Appeals. And it says, and we quote in our brief, although the jury is to fix the amount of the fine and report it with a guilty verdict, it is the trial court that is obligated to impose a fine, if any, not to exceed that fixed by the jury as part of the sentence. And it says see TCA 4035-301B. The trial court's imposition of a fine, if any, is to be based upon the factors and principles of the 1989 Sentencing Act, such as prior history, potential for rehabilitation, financial means, mitigating and enhancing factors that are relevant to an appropriate total sentence. Thus, the trial court may not simply impose the fine as fixed by the jury. And I think that makes sense in light of the fact that we do not have jury sentencing in this state, that a trial court would have to evaluate the fine set by the jury in order to make sure that it comported with and fit with the nature of the offense. So there is basis in case law for it. And we would just argue that the court consider that, even though the objection was not rendered at trial. It is a sentencing issue, and one on which we are not seeking the basis for a new trial. And with that, I conclude my argument. Thank the court and counsel for the state for their time.
Thank you. For any other questions from the panel? Seeing none, I wish to thank your offices and yourselves for continuing to allow us to have our oral arguments by Zoom. We are going to try to return in person in June across the state. We'll see how that develops with watching the COVID spikes, and hopefully we have none. This has been a wonderful alternative, not one I think we all prefer, but it's at least become it's pretty easy. We're getting it done. And I want to thank your offices and what y'all have had to do to accommodate us in doing this. And I also wish to shout out to the clerk's offices for their help and the AOC's offices for their help. With that, seeing there's no other matters to be presented, Madam Clerk, would you retire us to the call of the next case, which will be at 1 o'clock?
This court is now in recess until 1 p.m.
Thank you.
Thank you, Your Honors.